Good afternoon, everyone. My name is Kristen Solis. I am one of the mentor attorneys here at the Dallas Volunteer Attorney Program. And for those of you that are not familiar with us, we are a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys that will do their case from start to finish. So today we are going to learn about malpractice law and how to avoid it. So with what we're going to learn today, that there is good news and bad news. The bad news is that yes, you can get a grievance even in a pro bono case. The good news is we have Robert Toby here today to tell us how not to do that. Um, Robert is a shareholder and partner at Johnston, Toby, and Baruch. Uh, their office mainly does legal malpractice law. Robert is board certified in consumer and commercial law. He is currently an elected director at the State Bar of Texas Board of Directors. He is a past president of the Dallas Bar Association. He is regularly listed in D Magazine as one of the best attorneys in Dallas and regularly listed as one of the best attorneys in America. And he's a frequent speaker on malpractice and legal ethics issues. If you have questions during the presentation, please put them in the Q&A, and Robert will try to get to them at the end if there's time. And without further ado, I'll turn it over to Robert.
Thanks so much, Kristen. And just to follow up on what Kristen said, uh, I will try to get to your questions through the Q&A, but if I don't get to them, my email is robert@jtlaw.com. Again, robert@jtlaw.com. And I understand that Marcella has got my PowerPoint. There's also a conflicts checklist that I will send to her afterwards. But if y'all would like to get those from me directly with a question or whatever, I'm happy to respond and send those to you. So again, you've got my email. Look forward to hearing from you with any questions. Now, as I understand it, our audience is kind of a general audience. We've got varied practice areas. We've got various levels of experience in the audience. So I'm going to keep the remarks pretty general. And again, if there are specific questions, put them in the Q&A. I'll try to get to them. But if not, I'm happy to answer them at any time afterwards. So let's fire off with this with, first of all, a yeah, got freeze here. Let's see. Here we are. All right, I'm just going to pop these up here. And these are, Kristen referenced a grievance, and these are the top five areas that we see for grievances. Communication, 28%, integrity, 24, neglect, 23, declining or terminating representations, pretty common, shockingly so, 14%, safeguarding property, 11%, that's trust accounts and things of that nature. And in terms of avoiding grievances and kind of avoiding malpractice, they really kind of dovetail with each other. And so I'm going to talk about these kind of interchangeably throughout the presentation here this afternoon. Well, let's start with ABA Formal Opinion 498. And I want to talk about remote work because, when the pandemic hit back in 2020, I was actually president of the DBA at the time. And it was quite a bombshell for all of us, and none of us exactly knew what had happened or how it was going to go and all that. But one thing that was common was everybody started working remotely and doing it pretty quickly. The pandemic ended a couple of years later, and most of us came back to the office, but there's a sizable percentage of us that decided not to come back to the office, that working at home or wherever they wanted to work at from Starbucks or whatever was kind of a good deal. And there's a number of issues associated with remote work, and I think it's important to go over those just so everybody kind of understands. And this ABA opinion really makes it very clear that whatever the rules are when you're working in an office, they apply with equal force, if not more force, when you're working remotely. So obviously you've got issues of competence. For me, when we went remote and I went home and both my kids came home and we had downsized our house and we had two dogs and it just seemed like so much commotion all the time. It was very hard to focus at home the way I can focus at the office. So what slips when that happens? Competence. And that's something you really always need to guard uh, against is slipping competence and making mistakes that you would not make if you had a quieter, more professional environment sometimes. Diligence tied to that as well. Communications, this is where we really experienced a lot of problems. And that in dealing with your staff, it's really important to make sure you have a good, clear, open line of communication that's available throughout the day, just the way it would be if you were in an office and everybody was sitting within a few feet of each other. It's important that you make sure that is as good as it is if you were in an office. And that's why I noticed there was, at least in our personal work situation, a definite slippage, and that was communication with the staff. So make sure you safeguard that. If you're working at a Starbucks, and I walk into a Starbucks from time to time and I just see people working away, and I know some of them are lawyers, remember confidentiality is something we're all bound to. It's a fundamental concept that we have to deal with, Rule 105, as well as the attorney-client privilege under Evidence Rule 503. You got to safeguard those at all times. And when you're working in a public place, that's difficult. And just a reminder, don't use public Wi-Fi. If you have to, be on the network as opposed to being on a public Wi-Fi because that is absolutely not secure. There's no guarantee of confidentiality, invites hackers to come in and do mischief, and all of those things become huge problems in a situation like that. Supervision, obviously, your role there is to make sure you have good supervisory techniques in place, even though you're working remotely. And again, I find that to be more challenging than it is if you're in an office environment. So basically, as I said earlier, same rules apply. And if you're prohibited from doing something in person, you're still prohibited if it's virtual. Uh, and think about your technology and work environment. And again, confidentiality is number one, but having a good technological system in place is essential because otherwise, you can miss filing deadlines because your computer goes down or you don't have a good Wi-Fi connection wherever you might be, or whatever it is, you've got to safeguard that and make sure it's up to snuff. And that is very, very important. And again, your obligations, actually, your ethical obligations can be greater and not less in a given situation. So let's shift gears here and talk about wellness. And when I was in the run-up to become Dallas Bar President, I started attending a number of ABA meetings and other meetings where you kind of hear statistics. And these statistics, I'm just going to pop them up here. It is shocking. Lawyers are impacted far more than any other profession, whether it be doctors, architects, engineers, accountants, you name it. Lawyers are disproportionately impacted by problems with wellness. And these statistics are very alarming. It used to be that it was the more seasoned lawyers, the lawyers like me with the gray hair, that had the problems. But now that's shifted to some degree, and it's the law students, it's the young lawyers who are disproportionately impacted by these wellness issues. And statistically, 32% of lawyers 30 years old or younger have a drinking problem. And I gave this presentation about a month ago to SMU Law School, and there were probably 100 young folks in the room. And I said, look to your right, look to your left. Statistically speaking, one of you has a problem. And those statistics are out there and they're alarming. I hope they don't apply to you, but statistically they do. And you've got to be alert to that. 28% of lawyers struggle with depression. 19% demonstrate symptoms of anxiety. I would say that sounds like a pretty conservative number because I think we all have anxiety sometimes through the practice of law. And most alarmingly, 11% of lawyers have had suicidal thoughts at some point in their career. And again, our profession is disproportionately impacted by suicides. And so it's one of those things where you've just got to be vigilant. You've got to think about it. If you have a problem, we do have one of the very best resources in the country, the Texas Lawyers Assistance Program. It's put on by the state bar. You should have the hotline number at your disposal. And as importantly as it is for you in a given situation, it's even potentially more important to know that you can report somebody and it's completely confidential. Your name will not be revealed, and you could wind up saving a life that way. So think about it in regard to others. We're in a situation where, good grief, in the past 18 months, we've had to report two people to TLAP, and I hope they got help because they needed it. And it was a very, very bad situation and one that I hope ended well for both of these lawyers. So it's one of those things, nobody likes to talk about it, nobody likes to think about it, but it's out there and it's not going away, I'm afraid. All right, I want to talk next about having insurance and not only having insurance, but understanding it. I think about the situation where, I'm driving my car, I reach over to change the radio station, and 999 times out of 1,000, there's no issue. But, one time out of 1,000, a kid on a bike pulls out in front of you and you're momentarily distracted. So, I mean, that's why you have insurance. And we're all human. We all make mistakes. You're not going to go through a career of law practice without making mistakes, and probably lots of them. The good news is most of them are correctable, but sometimes they're not. And that presents a problem. So, again, carry insurance. It's vitally important that you do so and understand what you have. And let me go through a couple of kind of general terms with insurance that you should just have at your disposal and an understanding of them. And let me give an example kind of that comes out of litigation. And let's just say there's a case and the expert designation deadline is missed. Well, and let's just say that, you know, the deadline's missed, it can't be fixed. The case goes all the way up on appeal and the error is never corrected and your client loses. And then they assert a claim. Well, uh, the law in Texas and under most of these insurance policies is that the carrier that you had when you missed the deadline is not on the hook. It is the carrier you had when the claim was made. And that could be years later under that example. And so that's the carrier that is responsible. So obviously, you want to make sure you have continuous insurance. Don't have gaps in it. Don't let it lapse. Pay your premium. That's essential. Next, lawyers change firms all the time. That's about as common as, today being Wednesday. So when you change firms, make sure with your new firm that you have what's called tail coverage that'll provide coverage for prior acts that were done at your prior law firm or in your prior practice if you were on your own. So with tail coverage, a claim comes in, your new law firm is not going to be responsible for something that happened before. So their insurance policy is not likely to cover you. So you're going to be relying on this tail coverage to provide coverage if a claim comes in. So again, it gives you that protection and the ability to sleep at night for something that may have happened years ago. This last point with cannibalizing policies, I'll give another example. Let's say a claim's asserted against you for $750,000. You have $1 million policy, you turn it in, the insurance company hires counsel to represent you. and you're sleeping just fine, thinking, I've got plenty of coverage. I'm not in trouble here. Well, every time your defense lawyer does something, that erodes the limits of the policy. And there can be situations in a hotly contested case where you're getting near time of trial, and you might, instead of having $1 million policy, by that time have a $700,000 policy. And if the demand is still out there at $750,000, you're in an excess situation or a Stour situation. And that's something that, you need to be concerned about. So not only should you understand these particular policy provisions, but make sure you keep track if a claim's presented about what's going on and what your limits are and what your lawyer is doing to defend your case. All these things are important. So be involved in the defense of the case is kind of the moral of the story. Let's talk about limitations because that's kind of a tricky thing in this area. Legal malpractice is a form of negligence claim, so it's a 2-year statute. Breach of fiduciary duty, on the other hand, is akin to fraud. It is a 4-year statute. So different lengths in terms of the claims that are commonly asserted. The discovery rule definitely applies. So it can, again, be going to the transactional context here, maybe a mistake's made in a purchase agreement. And it could be years later before that clause comes into play. And if it does come into play, then the discovery rule will apply, and a claim can be asserted then with a 2-year statute of limitations on it. In litigation, going back to the example I gave of the missed expert witness designation deadline, uh, what's called the Hughes or the litigation tolling rule applies to that. And basically, if the deadline is missed, the statute of limitations does not begin to run until the case is over. Whether it's a settlement that happens the next week, whether it's denial of petition for review by the Texas Supreme Court, whatever the circumstance is, it's not until the case is over that the 2-year statute starts to run. The principle behind that's a good one, and it is that a lot of errors can be corrected in the course of litigation. And so it becomes kind of a so what? And that's what we all hope for, obviously, is that an error is fixed and it becomes no big deal. But that's the principle behind this. The tolling rule probably doesn't apply to transactional malpractice, but the discovery rule absolutely does apply. So again, the moral is you can make a mistake on January the 14th, 2026, and it might be January the 14th, 2029 before you hear about it. So those are the concerns that you have. Well, let's talk next about communications. As I showed you at the beginning, that is the number one source of grievances. It's also probably the number one source of malpractice claims because communications are so important. And our Rule 103 is the key, and it has two parts. First, a lawyer shall keep a client reasonably informed about the status of the matter and promptly comply with reasonable requests for information. Okay, so what's the easiest thing to do there? Copy the client on all emails. Maybe not when you send it to opposing counsel, I'll get to that in a moment, but send the client everything that goes on. That way, the client can't say, hey, I didn't know what was going on. I couldn't make an informed decision. So, by doing that, that alleviates that problem. Secondly, not just keeping the client informed, but also explaining the matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So, don't just forward the email, explain what's going on to the extent that's necessary. So, very important, those two parts. So, let's talk about ABA Opinion 503. And I can demonstrate this one with a personal story. I had a client years ago. His son was a lawyer, a very bright guy, not just a lawyer, but a really smart lawyer. And I used to copy him on emails to the other side because he was part of our client group. And there was one time where he blew up and sent a response to everybody, and I learned my lesson then. Don't do that because again, here's the other downside to it. Besides the fact that your client might react with the other side on the email chain, the other side has the absolute right to reply all as well when your client's on the email chain. That is, in effect, kind of a waiver of the prohibition against communicating with the other side's client. And as a result, the other side seeing your client copied on the email may structure an email in a way that um, causes you a problem with your client. Let's put it that way. So you've got to be on guard about that. My recommendation, based on that personal experience and other experiences that people have told me about, don't put your client on the email chains. Forward them separately. It's a lot safer. And if they blow up, they're blowing up at you, not the other side. This one, I'm going to give credit to Carrie Faniff. She's one of my good friends on the defense side. She's now a lawyer at the Texas Lawyers Insurance Exchange in Austin that provides liability insurance for lawyers. But this one is so important. I mean, if you think about a claim being made against you, if your emails are full of emojis and that type of thing, and it winds up in front of a jury, God forbid, it just makes it look like you're not a serious lawyer. You don't take your job seriously. Maybe you're a clown. I mean, it just is, it's the wrong thing. And I think Carrie's suggestion here is one that we should all adopt uh, and just don't do it. I mean, it's one of those things where there's no upside to it and there's a lot of downside potentially. This one, I I used to tell people don't text, and that's obviously just that cow is out of the barn. Let's put it that way. So people are going to text, and I have clients that, they just don't read their emails. And so you have to text with them to get information to them. But the prudent thing to do is to, in any important communication, make sure it is also documented in a more permanent form, such as an email. And I usually will tell the client, here's what I'm thinking in a text. Please read your email, which will give you more detail about the strategy. Please respond to the email with, your go ahead to go forward with this. So I think it's very important to document better because if your phone falls in the swimming pool or some other body of water, and you lose your text, then you have absolutely no ability to recreate those communications. So you want to have a more permanent form as well as the text. Just one of those things. I understand that people are going to text. Just take care when you do. Let's talk about conflicts because no talk along these lines is complete without talking about conflicts, at least to some degree. Again, you got to remember each time you represent more than one client, you have a duty to each one. So remember, there's a duty owed, and it's a fiduciary duty to each client. So it's very important that you make sure that um, you've thought about what can go wrong at the front end. This one, my friends on the defense side and I part ways a little bit. And basically, I think it's bad generally if these two folks are in your conference room, or three folks, or four folks, however many it is, at the outset of the representation, and you see there's division in how they're dealing with each other. My friends on the defense side will say, well, Robert, that's why you have a multiple client representation letter with a waiver, and you're okay. Well, I respectfully disagree with that point of view. I think that the waiver will only protect you potentially if everybody is singing Kumbaya in your conference room at the outset. If they're not, if they're at, if they're evidencing adversity at the beginning, whether it's a transaction, whether it's a lawsuit, that is only going to get worse 99.9% of the time. It's not going to get better. It never gets better. It only gets worse. Don't want to ignore a conflict. That's a huge problem, makes things worse by ignoring it. And if you're, for example, the guy who's drafted the partnership agreement or the LLC agreements with an operating agreement, et cetera, and the two parties in a dispute about the terms and what they mean, don't be the one who defends your work in court. And even my friends on the defense side agree with that one. You want to have somebody else defend your work in court in the face of a challenge. And don't take sides in a challenge like that because the other side will say, well, you breached your duty to me because obviously you had your loyalty to this other party. And by doing that, you have breached your fiduciary duty to me. And taking a side in litigation in terms of the meaning of a contract clause or an operating agreement or whatever it is going to give rise to arguments like that. Let's talk about engagement letters. Obviously, I recommend them in all instances to have an engagement letter. And here's kind of the minimum context you should have in them. You definitely want to list all persons and entities to be represented. That's critical. You don't want to have unintended clients, and I'm going to talk more about that in a few minutes because that's a real danger in pretty much every area of the practice of law. So you want to make sure you list all persons and entities to be represented. You want to clearly define the scope of representation. That's not so difficult in a litigation context where you're handling a lawsuit for somebody. But in the transactional context, it can be a very big challenge because what can happen there, for example, you represent the developer or the driller in ABC drilling venture number one, and maybe it's a big success. It's a gusher of a well. The investors all get paid back, and then the driller goes in the same area and puts out XYZ drilling venture number two, and maybe that well is a dry hole, and the investors lose their money and they're upset. And he comes to you and says, "Well, why didn't you protect me in this XYZ drilling venture number two?" And you can say, with accuracy, I didn't represent you on that. I have an engagement letter for ABC, drilling venture number one, but not one for XYZ. I didn't represent you in that. That's your problem. And that will protect you in those instances where it goes beyond the scope of representation. You also want to define how hourly rates will change if they are. And why is that important? Well, if you sign a client up on December 15th at $300 an hour and then on January 1st, you raise your rates to $400 an hour and haven't told the client that you're intending to do that or might do that even, well, then you've got a problem. You're going to have a disgruntled client in month number one of the representation. So, very important to spell that out on the front end. Also, explain how expenses will be handled, the right to withdraw for non-payment of fees, and the use of retainers. So all that needs to be spelled out very carefully, especially if it's a non-refundable retainer, which can be obtained in some instances beyond the scope of my talk today, but that's an issue that's out there and be careful with it. Multiple client letters. So if you decide to go forward with multiple client representation, make sure you have it documented as thoroughly and completely as you can. It's very, very important. I was just got off the phone before this with another lawyer who does malpractice defense for a living, and he was talking about how to structure a multiple client representation by their law firm. And so it comes up all the time. And you want to make sure in your letter that you've got at least the following in there. The client should confirm there are no conflicts. So that's helpful. You want the client to inform you if a conflict occurs, and that deals with the situation where maybe you're sitting in your office thinking everything's okay, And indeed, these clients are in the background somewhere fighting, and you have no way of knowing that. So you want to have the affirmative obligation on them to advise you if a conflict has arisen. You want each client to consent to the joint representation. Very important to have that. And you want the written recommendation that each client get a separate lawyer. And, it's really very essential to make sure that point is spelled out because you do have a duty to each client. It's important that they understand that. And again, it's plaintiff's exhibit number one, so make sure you get it right. It's also important to spell out that there's no privilege between jointly represented clients. Uh, there are some clients who say they get that, but then when push comes to shove and they've got something that they'd rather not reveal to the other jointly represented client, they're telling you don't tell the other party this, and you can't do that. And that can cause a conflict that causes you to have to withdraw from the representation potentially. So those situations come up, so it's important to spell that out. So it's very important here when you've got these issues, you've got Rule 106, that is the transactional client rule, and that's the rule where, if you're representing the deal, you're representing the LLC, the corporation, the partnership, whatever it is. You're the scrivener of the will, but you're not representing any of the constituent parties to that. Make sure you put that in writing and make sure it's understood you don't represent any of the constituents so you don't have any of these unintended clients. Secondly, the intermediary rule, Rule 107, and that is the joint client rule, and they do require strict compliance in both. And let me talk about, in connection with the joint representation, Rule 107. There was a draft conflicts checklist that was prepared back in 2010. There was a rules referendum to substantially rewrite the disciplinary rules. Had some controversy to it, things like you should not have sex with your clients. That raised a firestorm for those of you who were practicing back there. Probably remember that very well. And basically, the rules were voted down like 85-15. They were just crushed. But this conflicts checklist that was drafted back then is a tremendous resource. I'm going to send it to Marcella, but for those of you who don't get it that way, feel free to email me to get that checklist. I use it, I printed it off, I have it in my desk drawer. Anytime I have a joint representation that I could decide we can go forward with, I use that to draft the conflicts checklist letter. I mean, it is that important. It has pretty much everything you would need in it as an element to go in your letter. So please use it. If everything else I tell you goes in the electronic round file, do use that because it will benefit you in your practice. I've been talking about this kind of obliquely for the past few minutes, but uh, these unintended clients is a huge area, very, very important area of the law. And let me give you an example, which is this Parker versus Carnahan case. And from that example, you'll be able to see that it could come up in almost any area of the law. But in Parker versus Carnahan, Dr. Parker, a dentist, and his wife went to see Carnahan, a tax lawyer, because Dr. Parker had a bad habit of not filing his tax returns. And the IRS was not amused and came after them. And so they meet with Carnahan and he says, look, here's what we're going to do. We're going to prepare the back tax returns. We're going to get them filed. We're going to work out a payment plan with the IRS and everything will be okay. And so they proceed to do that. And the back tax returns are filed, married filing jointly. Well, what happens? Dr. Parker stops making the payments. He and Mrs. Parker get a divorce. Dr. Parker then files bankruptcy. And again, the IRS, not amused by these antics, comes after Mrs. Parker and forecloses on the house she gets in the divorce. And she brings a claim against Carnahan and says, wait a minute, you didn't protect my interests here. These tax returns should not have been filed married filing jointly. They should have been filed married filing separately, so that when the good doctor defaulted on the payments, the IRS could not come after me for payment on these back taxes. Carnahan says, nope, you can't sue me. I only represented the good doctor. I didn't represent you. Well, here's what the Texarkana Court of Appeals said. And that's basically if the lawyer is aware or should have been aware that the lawyer's conduct would lead a reasonable person to believe that the lawyer was their lawyer, an attorney-client relationship can be formed. Wow. So you think about the application of this. Think about if you're handling a car wreck case and you've got the driver and the passenger in your conference room, and you only intend to represent the driver. Well, it's very important to write a letter to the passenger and say, hey, I'm not your lawyer. We do not have an attorney-client relationship. I recommend that you retain counsel as soon as possible to protect your rights in this matter. You write that letter, you will not have the passenger as an unintended client who will be mad at you if you don't protect their interest, as surely you will not. If you've got the general partner and the limited partners, or the manager and the members of an LLC, or the um, officers and the directors of a corporation in your conference room, and you're only intending to represent one or two or less than all, make sure you make it clear to these people you are not representing that you are not their lawyer. There is no attorney-client relationship with them, and they should retain their own counsel to make sure their rights are safeguarded. So if you do that, you will avoid the problem with these unintended clients, which again can arise in the transactional context, it can arise in the litigation context, and virtually any situation where there's either more than one person or more than one entity in a person in your conference room, these issues can arise. So be careful. And so much of this is just a pain. I mean, you're sitting in your office at 5 or 6 o'clock, kind of tired, ready to go home. But one of these situations has come up. Spend the extra 15 minutes and crank out a letter spelling this out. And the 15 minutes you spend there will save you potentially hundreds of hours and untold amounts of money in the future. It's that important. So paper is patient, get it in writing. This slide encompasses a lot of things. And again, it's all about communication. Fee agreements we've talked about, multiple client letters we've talked about, agreements to limit the scope of representation. This can come up in many different contexts as well. Um, an example in the litigation context, a lot of lawyers who do trial work do not want to handle appeals. Well, if you do trial work and there's a trial, chances are there might be an appeal. And if you haven't told your client, oh, by the way, I don't handle appeals, and the judgment's entered and one or both parties decide to appeal, and you're telling your client at that moment in time when the 30-day clock is running, oh, by the way, I don't handle appeals, you're going to have a pretty mad client in that instance. So make sure you spell that out on the front end, because the client may want to get somebody that will handle an appeal if it becomes important at the end of a case. So very important to document that. Another situation where this comes up is less frequent, but it does happen. And that's where a client comes to you and says, look, I've been sued, but Joe Smith is the lead defendant. His lawyer's going to do the discovery and take the lead on all this and take the lead at trial. I just want you to sort of make sure I don't get screwed here. Well, that may work out, but if you don't tell the client that this is a very bad idea at the outset, and this scenario comes up, which is Joe Smith settles out right before trial, and your client is the one on the hot seat at that point, Well, and if you haven't spelled out the fact that this is a really bad idea, I caution against not doing anything to prepare the case for trial because the lead defendant can settle out or get dropped or whatever might happen, in which case you're on the hot seat. And so it's super important. My advice is don't do this because it has such a high risk of something bad happening. But if you do, spell it out and make sure you spell out the fact that this is a bad idea. This next one, I can't count the number of times where we've had a potential client come to us and say, hey, there was an offer of settlement for $100,000. The lawyer didn't tell me. If the lawyer told me, I would have taken it. So I've been damaged $100,000. Well, chances are what the client is saying is false. The lawyer probably told the client there was an offer, but did it verbally and didn't send an email to confirm the fact that the lawyer had received the $100,000 offer and I'm transmitting it to you and I need your response in writing to the offer. Because chances are the client thought they had $1 million case. Everybody today thinks they have $1 million case. It doesn't matter what it is. It's $1 million. And, chances are this client's saying, oh, $100,000, that's an insult. I would never take $100,000. Well, if you don't have that documented in some fashion, you've got a problem. I mean, on its face, even if it's not true, if this client says you didn't tell me about this offer, and if there's no piece of paper transmitting it to the client, it didn't happen. Even if it did, it didn't happen because the jury's never going to believe the lawyer over the client in that situation. So make sure, regardless of the circumstances, document the fact that you got the offer and how the client responded to it. So even if it's a memo to the file as opposed to an email to the client, make sure it's documented in some fashion that's a permanent method of documentation, not a text, an email. Recommendations against taking certain actions. We represent people we like to call sophisticated consumers of legal services. Many of them have been in lawsuits. They understand how lawsuits work. Many of them have formed LLCs or corporations or limited partnerships. They have a pretty good idea of how entities are put together and formed and how they're structured. But I tell you what, they're not nearly as smart as they think they are most of the time. Sometimes they are, most of the time they're not. And virtually all these people who have been through it are opinionated and have strong opinions about what should be done in the representation. And largely, you have to follow their decisions, even if they're stupid. But if they are stupid, it's very, very important to write them and say, here's the proposed strategy that you want to do. I recommend it, and here's why. I recommend against it, and here's why. Because this can happen and that can happen, and none of these are good. So my recommendation is you don't do it. So if you send that, you will never hear back from them say after their strategy goes bad, why didn't you warn me? Because if you don't warn them in writing, they will argue almost as sure as could be, this strategy didn't work. You should have warned me it wouldn't work. And if you do that, if you do warn them, they will never be able to make that claim successfully. So rejecting potential clients and the statute of limitations, very, very, very important area. Uh, it's very important that you train your screener, whether it's you training yourself, or if it's a legal assistant or some other person you have who is screening potential cases for you, what generally the law is on limitations, so they have an understanding and they understand what questions to ask the person to make sure that limitations either haven't run already or are going to run imminently. And by way of example, if you handle a car wreck and it's been 1 year and 360 days since the car wreck happened, and your intake person gets the information and hands it to you, it doesn't say anything, and you drop it on the floor because you're busy with other things, and 7 days go by, well, you've committed malpractice because limitations was blown while that potential case was sitting on your floor. So it's very important to have a policy in place. And ours generally is 6 months before limitations. If it's within that time, we either make a decision very quickly or we just go ahead and reject it and tell somebody it's too late. You got to go get somebody else. We're not going to look at it that close to limitations. Regardless of whether it's a month, 2 months, 3 months, 6 months, a year, whatever your standard is, be true to it and make sure your intake people have the information to make a at least preliminary judgment about limitations. And if they're imminent, go ahead and just reject that person on the phone so that you don't get in a situation where limitations can run while the matter is sitting in on your desk or on the floor next to your desk. So very important. So when you have these people come in and maybe you decide after that to reject them, it's very important once you've gotten a certain amount of information from them. And if they call and you reject them on the phone, I wouldn't worry about it so much. But if they call and give you information and you then decide to reject them, to address the statute of limitations. And whenever you do, unless you are 288% positive you know the date, do not say when limitations will run. Because again, if it's the car wreck case and you tell this potential client that the statute's going to run on January 14th, 2026, and the statute ran on January 12th, 2026, and the clients filed a lawsuit on January 13th, well, you've blown limitations in your advice. And maybe it doesn't matter. Maybe it was a bad case. But regardless, you're facing a potential claim from somebody who got bad advice in terms of when the statute ran. So it's much better in your termination letter or rejection letter to say, we're not your lawyer. There's no attorney-client relationship. We recommend that you retain other counsel to represent your interest and protect your rights. It is also important to know that the statute of limitations is running on your claims. Generally, claims for negligence are governed by a 2-year statute. We do not have sufficient information to determine when the statute began to run or when it might run on your claims. So you should act as promptly as possible to make sure your claims are safeguarded. Language like that, you will not get in trouble for having given bad advice as to when the statute runs. And so very important to be careful on that because that is a huge trap for the unwary. And again, getting it in writing will protect you from the foibles of human memory. And it discharges your obligations under Rule 103 to make sure you've documented everything in writing carefully and you've given adequate communication. Run your practice like you run your home. I mean, this one, um, I think about situations where I'm at home on a Saturday afternoon and maybe I'm watching the Longhorns and the doorbell rings and my first thought is, golly, can I just hide and maybe not answer the door? But maybe in a moment of weakness, you get up and go answer the door, and it's somebody wanting to sell you something of some sort. And, you know, maybe you have bad thoughts that maybe you're just thinking, I wish this person would just disappear. Well, maybe that speaks ill of me anyway. I know I have those thoughts, but um, you think about it, you're sitting in your conference room and somebody comes in and, just to put it bluntly, you just don't like the person. I mean, that happens to me, not all the time, but sometimes it happens. And there are times in my career where I've taken those people in as clients, and boy, did I ever regret it. I mean, it was a horrible experience. If you're not getting along at the outset, or they're just a bad personality mix for you, don't take that case. Refer it to somebody else. Let somebody else determine if they're a good match for this person. Because if you take it and things go bad, as they are likely to, because again, the case is never as good as it is that first day when the client's in your conference room and you haven't heard from the other side, and all the arguments that the other side's going to make are generally unknown to you. Just reject it. I think it was Will Rogers who said he never met a man he didn't like. Well, most of us are not Will Rogers. And if you meet somebody you don't like, refer it out. It's the safest thing to do. It will go much better. And again, we think about what can go wrong when we sign a client up with their case. Well, think about what can go wrong when you're representing somebody with that representation relationship. That's just as important as what can go wrong in the case. Because again, if you have a bad client relationship, that's not going to get better. Don't be greedy or desperate. Now, I've had this slide in for a while, really ever since the uh, 2008 crash, economic crash. Because I tell you what, that was like everybody got collectively hit over the head with a baseball bat. We looked at our financial position one day, and then seemingly 2 months later, it was 40% of it had just disappeared. It was horrible. And it hit lawyers really, really hard. And big firms, they don't run their practices the same way they did before. It's totally different now. And if you're not making money, you're out the door. I mean, none of the, good time served type thing. So this is one of those things where when times are good, it's easy to be disciplined about what you do. But, when the roller coaster kind of is on a downswing, it's a lot less easy to be disciplined. I mean, those of you who've come out of school with student loans and are still paying them off, that obligation doesn't go away when times are bad. The obligation to feed your family, to educate your kids, all those things that are out there, those obligations don't go away when times are not as good as they are, at other times. And so, but you got to be disciplined in your practice because you can take cases you shouldn't. You ask for fees you don't deserve. You ignore conflicts that should stop you cold. All those things are out there. You just have to be disciplined no matter what the situation is. This next one, back before House Bill 4 in 2003, uh, you could sue a doctor in this state. Now it's very, very hard to do that. But back in those days where you really could sue a doctor for a lot of things that you can't today, they developed a lot of great loss prevention strategies that we as lawyers should adopt as well. And, one of those is you get signed consents and you think about doctors, maybe you got ticker trouble and you go to see your cardiologist or the heart surgeon, cardiac surgeon, and, he or she tells you, well, here's what we're going to do. We're going to cut you open. We're going to remove the bad artery. We're going to put a pig valve in there and sew you up, and you're going to be great. And in fact, when he hands you the consent form, it says 50% chance you die on the table, 80% chance you're confined to a wheelchair, 90% chance you lose blood flow to your brain and your brain damage, all these horrible things, kind of like the drug ads on TV. And, so it needs to be informed consents, and that's really important. And doctors, pretty good about explaining the things that can go wrong. Well, we've got to be good as well from the legal standpoint. So it's not enough just to get your client to get consent. You want to make sure it's informed. Very important. This one, we live in an age of just sort of instant gratification. Uh, we live in what I like to say is a 15-second world. Commercials are 15 seconds now. They used to be a minute because Madison Avenue has figured out that people's attention span is 15 seconds. And if you don't get your message across then, you'll never get it across. And so it's the MTV generation of just instant answers to everything. And, think about a cocktail party where you tell somebody you're a lawyer And, chances are they just launch into the fact that they're in the process of getting divorced. It's been going on for 2 years. They think they're getting screwed by the other side, and their lawyer's not doing a good job for them. And they'll ask you, well, what do you think? Well, when they've had a 5-minute rant on something that's been going on for 2 years, there's no way you can give them an intelligent answer. So what do doctors do? They say, wow, I'm sorry to hear that. Call our office on Monday. We'll get you an appointment. We'll get you in. We'll do some tests. We'll figure out what's wrong and a treatment plan. Well, that's what we need to do as well in those situations. And, even more common than the cocktail party is them calling you on the phone. And you've got a potential client who launches into, a 5-minute rant about something that's gone on for 2 years, and they'll want to know, what do you think? What's your preliminary thoughts? What do you think? And there's no way you can give intelligent advice in those situations. So, you know, the response is, I'm just trying to get enough information to know if I'm even the right lawyer to talk to. If I am, we'll set up an appointment, get you in. We'll talk about it at more length. We'll get some documents to look at. We'll decide, what the next steps are, if any. And so, again, people want instant information, and a lot of them are pretty good at dragging it out from you. So you've got to be wary of that because they'll get you in trouble when the advice you give them isn't quite right. Rejecting potential clients, again, put it in writing. Uh, again, I just went over this on the statute of limitations. And then when you're at the end of your representation and you're terminating the fee agreement, Rule 1.16, this used to be 1.15, but we had a rules referendum last year where we got some new rules. So it's 1.16. And that says the lawyer may retain papers relating to the client to the extent permitted by other law, only if such retention will not prejudice the client in the subject matter of the representation. So back when the files were generally paper files, this was a very big deal. And it made a difference a lot of times in terms of what lawyers were willing to do. A lot of times lawyers would say, hey, you haven't paid me. I'm going to assert a lien on the file. I'm not going to surrender this until you pay me. Well, you can't do that under 1.16 because if the client can demonstrate any prejudice by you withholding their file, uh, you're probably going to be subject to a grievance. So it's very important that you turn the files over. You have to surrender the original file. That's very important. Now, with files being electronic, this is not such a big deal. It's easy to put stuff onto a flash drive or send it by a share file or Dropbox, whatever it is, but just send the client everything. And if you do that, you will not have problems, at least in terms of responding to the grievance committee about improperly withholding a file. And that still happens today, even though generally speaking, it's much easier to deal with that today than it used to be with paper files. And again, you probably should retain a copy of the file. Do not destroy it. Uh, it's important to retain a copy because if you do get sued in the future, you'll need your file to help protect yourself. And so it's very important to make sure you've done that. So, you know, be sure and let the client know I'm working on it. I'm making a copy. I'll produce it as soon as I can, but, there'll be no delay beyond that. And then you want to put the termination of your fee agreement in writing once a matter is over so that you can confirm with the client that the attorney-client relationship is concluded. Now, obviously, there are continuing duties of confidentiality that you have to that client, even though the matter may be over, you still can't really talk about it without the client's consent. Those rules continue to apply. I've got time for, I think, for this one last slide, dealing with difficult lawyers. And I think, over the years, that's been kind of I think it's gotten worse as with the advent of email. I mean, with email, uh, you have instantaneous communication virtually. And with letters back in the day, you'd get a letter in the mail, you'd dictate a response, you'd hand it to your legal assistant. He or she would type it out, you'd look at it, revise it, they'd give you another draft, and maybe you revise it again, and then you sign it and put it in the mail. And so by then, there's a cooling off time that you don't have with email. And so the main thing to do is to take a breath and stay calm because there's lawyers, and we all know who they are, who are really good at getting under your skin. And when they get under your skin, they've won. Then they have the opportunity to get you to get mad in an email, and then that becomes exhibit one to a motion to compel or something like that, and you look bad. And so it's very important to stay calm and take time before you respond, at least an hour, maybe longer. Do not feel compelled to respond immediately. Bad idea. Get advice from somebody more senior than you, or a friend or trusted confidant, whoever it might be, to make sure that you don't run into an instantaneous bad response that can't be taken back. And then think about whether to get help from the court. And, be judicious about this because courts don't like bullies. That's 100% right. They don't like that. But the other thing they don't like, and maybe they dislike this even more than bullies, are people who whine. They cannot stand whining. And so it's very important to pick your spots in terms of getting help from the court. Generally speaking, if you know, it doesn't work to put it in writing, try to call the other side and see if you can work out things that way without going to the court. Because a lot of times it's a lot harder for people to be rude on the phone than it is rude through written responses. And, with that, there's a whole lot more in this outline. I'm happy to send it to anybody who might like it. Again, it's Robert at jtlaw.com. Uh, and I look forward to hearing from you, and best of luck in your law practices, and avoid the traps that are out there for all of us. So with that, I'll wish you a good afternoon.
Thank you, Robert. Um, Let me pull up the Q&A to see if there are any
Okay.
questions.
Yeah.
In the meantime, I did include the MCLE course code in the chat, and that number is 174 305 083. Again, that is 174 305 083. I am not seeing any questions in the chat, but a copy of the presentation will be emailed to all attendees following today's presentation, which does include Robert's email. So if you do have any questions following today, please feel free to reach out to him. And we thank you all for attending the first CLE of the 2026 year. And thank you, Robert, for being a great speaker and a great presentation.
Thanks so much.
Uh, Seeing no questions, I adjourn today's session and wish everyone a good rest of your afternoon.
Thank you.
Thank you, everyone.